Thank you. Thank you very much, Jung, for this very kind introduction. And thank you again also as well to the organizers for having invited me to participate in this meeting. It is really a pleasure for me to be here with you today. I will be sharing with you some information regarding the use of the Madrid Protocol for protecting your trademarks in the European Union. After the presentations, very interesting presentations made by Peter Willemert and by Ms. Saiton Harris, I will be focusing more particularly on this topic and building on what they have already presented to you. Let me just say first a few words about European Union, just to recall that the European Union is composed by 27 member states that comprise a total of more than 450 million inhabitants. And this means that it is a very attractive market for Malaysian exports, for companies wishing to export products or services to these countries. And therefore, many companies from Malaysia may be interested in getting trademark protection in the European Union. Now, the European Union offers different ways of obtaining trademark protection in their member countries. In fact, there is what we call a four-tier system for trademark protection in the Union. There's first of all the possibility to follow a national route, that is to ask for the registration of a national trademark at the industrial property offices of 24 member states, 24 out of the 27 member states. You can go individually to the IP office of each of them and ask for the registration of a national trademark to get protection within the territory of that specific country. There are three countries in the Union, Belgium, Netherlands, and Luxembourg, that have built a joint office, the Benelux IP office, which delivers trademarks, the Benelux trademark, which has a validity in the territory of these three countries. So this is the Benelux route. If you want to get protection in these three countries, you can ask for a trademark at the Benelux IP office. I was referring to the four possibilities to obtain trademark protection in the European Union, either following the national route to obtain protection in 24 member states individually, the Benelux route to obtain protection in these three countries, Belgium, Netherlands, and Luxembourg, through a single trademark, the Benelux trademark, which gives protection in these three countries. Then you also have the possibility to use the European route, that is to ask for a trademark protection at the European Union Trademark Office to get European Union trademark that is valid in the whole territory of the 27 states that are members of the European Union. And finally, there's the possibility of the international route, that is to ask for protection through the Madrid system whenever you have an international registration or you apply for international application. You can designate for protection any of the above. That is, you can designate an individual through the Madrid system, an individual European Union member state, or you can designate the Benelux office for the to obtain protection in the Benelux countries, or you can also designate the European Union as such, as a whole. And this is because in 2004, the European Union as such became a member of the Madrid Protocol, which allows not only membership by individual states, but also by certain intergovernmental organizations that issue trademark rights. And in particularly at present, there are two intergovernmental organizations that are members as such of the Madrid Protocol, which are the European Union and the African Organization of Intellectual Property, OAP. So I will be focusing in this presentation, in this short presentation, on the use of this international route to obtain protection in the European Union as a whole. As a national of Malaysia, you can designate the European Union, and you can do so in your international application when you fill in the MM2 form that Mrs. Saiton Harris was mentioning. That is the form that you're going to submit at MyIPO, that MyIPO is going to send to WIPO, and then from WIPO it will be sent to the European Union office. This is how the MM2 form looks like. And the item 11, you can just simply designate the European Union by clicking this box next to the European Union name. The code used to identify the European Union is EM for European mark. You can also designate the European Union afterwards. If you already have an international registration where you have sought protection for some other members of the Madrid Union, you can ask for protection at the European Union by submitting a subsequent designation, as Peter Willemot mentioned. And this you do by filling in a different form, the MM4 form, which you submit directly to WIPO. And WIPO will communicate, notify to the European Union IP office. And this is how the MM4 form looks, very much similar to the MM2 form. And this, in item 4 of this form, you can designate the European Union in this way. Now, when designating the European Union, there are certain specific requirements that are particular to only for the designations of the Union. And there are two specific requirements, and these concern first a language, the second European Union Office language for certain proceedings, and the other specific requirement concerns a seniority claim. Let me briefly explain this. In the form that you use, either the international application form or the subsequent designation form, you must indicate either French, German, Italian, or Spanish as a second language. The European Union Office, IP Office, has 5 working languages. English is one of them, but these other 4 languages are also working languages of the European Union Office. And in principle, you will be filing your international application in English, and proceedings with the European Union Office will be mainly in English. In fact, most of the proceedings before the office, more than 60% of the proceedings of the office are run in English. Now, the need for a second language, indicating a second language, concerns particularly the cases of opposition, revocation, or invalidation initiated by a third party. For these specific cases, as we will see in a minute afterwards, you will be using English, or maybe you will find yourselves in the position of using different UIPO language, a second UIPO language, and you should choose from the very beginning which of these other languages you wish to use in case you have to use this other language because the third party that initiates the opposition, revocation, or invalidation so chooses. Regarding seniority claim, this concerns a particular feature of the European Union trademark system, and that means that you may claim priority rights of any existing national registrations for an identical mark in any country of the European Union. If you had prior rights in one country of the European Union before filing your international application for designating the European Union as a whole, you can claim seniority. And if you do so, this is optional. If you wish to claim seniority, you have to do it, if you do it at the time of submitting your international application, in a special form, which is the MM17 form that you can download from the WIPO website. You can also file a claim for seniority at the later date directly at the UIPO without the need to use this MM17 form. When you designate the European Union, you will have to pay some designation fees. The designation and renewal fees have the same level. For the first class of goods or services, it amounts to 897 Swiss francs, about the same 897 US dollars at present. And it's a relatively interesting price, accessible price, in order to obtain protection for a trademark for 10 years in the territories of 27 states. For a second class, you have to pay 55 Swiss francs, and for each additional class, you would have to pay 164 Swiss francs. Where the mark is a collective or a certification mark, the amount for the first class is relatively higher because of the specific needs of processing a collective or certification mark. What happens once EU designation has been registered at WIPO? Well, WIPO will notify the European Union IP Office immediately. The EUIPO will then republish the international registration in its bulletin, the EUTM, the European Union Trademark Bulletin, and then an opposition period will run as from the date of that republication. You can ask for possible searches within 1 month of WIPO's notification. You may ask the EUIPO to draw up a search report citing similar European Union trademarks and international registrations that have designated the European Union to see if you may have any conflicting trademarks there. But my advice would be to make an early search for similar trademarks in the European Union well before you file your international application. And this you can do by consulting TMView at this web address, but also by consulting the global brand database that Peter Willemer mentioned. Then the European Union IP Office will examine certain formalities, a limited number of formalities. The office will check whether you have indicated a second language for the proceedings. It will check whether you have given all the required data in the MM17 form if you have claimed seniority. It will check that all the goods and services EU designation fall within the scope of the international registration's main list, the main list of goods and services of your international registration. And it will also check that all the terms used to indicate goods and services meet certain requirements of the office, requirements for clarity and precision. That is, if there are terms that identify goods or services that lack the required level of clarity or precision, they may be refused. So it is good, and my advice would be to check TM Class. TM Class is a tool offered by the European Union IP Office, where you can find a list of terms that have been pre-accepted, pre-approved by the office, and where you can choose terms that you will be sure that they're not going to be refused. If your international registration is for a collective or certification mark, then the EU IPO will ask you simply to submit the regulations of use of the collective or certification marks within 2 months. And if any of these formalities that I've just mentioned is not complied with, the office will issue a provisional refusal and will ask you to remedy the deficiency within 2 months. But if everything is okay, the office will proceed to substantive examination. In principle, and this is very important, you will not need to appoint a representative unless the European Union office issues a provisional refusal of your international registration, or if you wish to file a seniority claim directly before the office. And in such cases, because you're located outside the European Union Economic Area, you will be required to appoint a representative who should be a person who appears in a database of representatives that is maintained by the office at this web address. Now, as soon as the formality check is completed, the office will move on to substantive examination. And for this, it will rely on, it will take into account what the European Union Trademark Regulation stipulates in Article 7, Paragraph 1, which says that your mark will be refused if it does not conform to the European Union trademark definition, or is non-distinctive, or is descriptive, or generic, or functional, or contrary to public policy or morality, or deceptive, or is in conflict with flags and other symbols, or in conflict with denominations of origin or geographical indications, or traditional terms for wines, traditional specialities, guaranteed, earlier plant variety denominations, and so on. So these substantive grounds on which the European Union may issue refusal. Now, once the substantive examination has been completed, the EU IPO will issue a notification. It will send it to WIPO and it will send it to you. The notification will be a provisional refusal if the sign of your international registration is non-eligible for protection, or it may be an interim status of the mark if your mark is eligible for protection. Now, if the office issues a provisional refusal, the office will give you 2 months to submit observations, and you may ask for re-examination, and then the office may decide to confirm the refusal or to waive the objection and accept your mark. If the office issues an interim status of the mark saying that it has found no difficulty with your mark, then it will send this notification to WIPO indicating that the ex officio examination has been completed, but the international registration is still open to opposition or to third-party observations. Now, any person invoking earlier rights in conflict with your mark may file an opposition, and any person may do so between the 1st and the 4th months following the republication of the international registration by the European Union office. Now, if someone opposes your international registration, the office will send a notification to WIPO provisional refusal based on opposition, and will send you a copy of the notice of opposition, and it will also notify you of the time limit for commencement of the proceedings, which will normally be within some 2 months or so. And in the communications with WIPO, the office will always use English in your case, because that's the language of your international application and of your international registration. But in communications sent directly with you, the UIPO will use the language of the opposition procedures chosen by the opponent, which may be English, but it may also be the second language that you have chosen when designating the European Union. As I mentioned earlier, the practice is that more than 60% of proceedings at the UIPO take place in English. Usually the second most used language is German, with less than 20% of the proceedings being held in German. After the expiry of the opposition period, it may happen that no one has opposed. If the formal and substantive examination of your international registration has been okay, nobody has filed an opposition, then the UIPO will issue a statement of grant of protection, and your mark will be protected in the European Union. Now, if the office has issued a provisional refusal, the office will take a final decision once all the procedures have been completed. And this final decision may be a confirmation of refusal or a statement of grant of protection following a refusal. And if it's a statement of grant of protection following a refusal, the office will specify for which goods and services is accepted. Then, if your mark becomes protected in the European Union, at least in part for some goods and services, for example, the office will republish again your international registration. And from that date, this date of the second republication, your international registration will have the same effects in the European Union as a registered trademark, European Union trademark, and will be valid in the European Union as long as it is renewed. Your rights may be invoked against any infringer in the European Union, and you must simply make sure that you put your mark to genuine use in the European Union within a 5-year period from republication, because otherwise you may risk revocation if your mark is not being used within that 5-year period. Now, there's a special feature I want to refer to of the European Union system, which I think it's relevant and interesting for you before concluding, and this has to do with conversion. The European Union trademark and the designation of the European Union under the international registration system, it's a very strong trademark, but it will not be granted unless there's no conflict with any trademark, any other trademark at the national level in any particular European Union country. So it may happen that European Union designation is refused because it is in conflict with a trademark, a previous trademark, a prior trademark in a particular country of the Union. If for whatever reason your designation of the European Union is withdrawn or refused or ceases to have effect, you may request a conversion. And conversion means conversion into a national application filed with the IP office of any European Union member state, or into a subsequent designation of any such state under the Madrid system. Suppose that your designation of the EU has been refused because it's in conflict with a trademark in Greece or in Bulgaria. But your interest, of course, is to have a trademark that is valid in the 27 countries of the Union, but it is refused, it gets refused because there's a conflict there. But there would be no conflict with any trademark in Germany and France. And your main interest is to export goods or services to Germany and France. Well, you can, in that case, if it is refused, you can convert your designation of the European Union into a subsequent designation of any state of the Union under the Madrid system, keeping the same date of the European Union designation in the international register. And if you want to do that, you should simply fill in a form, an official form MM16 that is available at the WIPO website, and you have to file it through the UIPO within 3 months from the date where the EU designation has been refused or withdrawn or has ceased to have effect. And you will follow then the procedure at those particular states where you want your trademark to get protection. So to conclude, the Madrid system is offering you a very user-friendly and cost-effective route to obtain and maintain protection for your mark in the European Union. You will be able to seek protection in the Union by simply ticking the EM box when you file your international application at MIPO or when you submit a subsequent designation at WIPO. As soon as your international registration is accepted by the European Union office, you will be able to enforce your trademark rights anywhere in the European Union. You will be able to renew your trademark rights in the European Union every 10 years by simply sending an online communication to WIPO and paying the required fees, which are the same fees as for an application, as I mentioned earlier. And you will certainly gain brand presence in the European Union, and you will be generating goodwill for your mark and possibly opening franchising or partnership opportunities. So I would encourage you to use the Madrid system to get protection for your mark in the European Union as a whole. And I will now be available for questions that you may have. Thank you.